Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. Welcome to the first webinar in our Handbook Mastery Webinar Series. We have a second webinar scheduled for December 3rd at 9 a.m. Pacific, 12 p.m. Eastern, focusing on the top 10 topics for 2026 handbook updates. Members of the Littler's Handbooks and Policies Practice Group will spotlight recent legislative changes that require policy updates for 2026 in key employment law areas, including leaves of absence, accommodations, paid time off, and equal employment opportunity. Of course, we are always interested in hearing your ideas and suggestions for future webinars in this educational series, so please feel free to leave your ideas and suggestions in the chat. For those of you who don't know me, my name is Jill Lowell. I'm a shareholder in Littler's Rochester, New York office. I serve as the co-chair of the firm's Handbooks and Policies Practice Group. I am joined today by my co-chair, Greg Tomolo, who is a shareholder in our Providence, Rhode Island office. We are also joined by Michael Worth, Vice President of Sales for complianceHR. Over the next hour, Greg and I are going to provide you with a deep dive into the top 10 handbook drafting and implementation mistakes that the members of our practice group encounter every day. We will offer practical tips on how to avoid these common mistakes, but please feel free to add your questions to the chat and we will try to answer them if time allows. Before we begin, however, we would like to provide you with a brief introduction to complianceHR, an incredibly powerful tool that we use every single day as part of our practice here at Littler.
Hello, everyone, and thank you for joining us today. My name is Michael Worth, and I'm from complianceHR, and we're part of Littler's innovation team. As you all know, January and July are typically heavy with regulatory updates. So I partnered with my friends at the Littler Handbook and Policy Practice Group to create an educational series that provide a handbook best practices framework before the wave of new regulation in January. I know this is an important topic to you because people are coming in very quickly. We have close to 1,500 people on the line. So thank you, times 2,000. And for others that may come in, we really appreciate your time. So I'm pleased to tell you that for the past 10 years, complianceHR has been providing self-service solutions that really simplify the complexity of employment law. We have risk solutions with Navigator Overtime and Navigator Independent Contractor that help with employee classification. You put in your fact pattern, we apply federal, state rules, and case law, and we give you insight on how you can classify and get a better risk assessment for that individual. We also have tools like the Reference Center, quick answers to paid sick leave, final pay, things that people need, all the information, accurate, up-to-date, straight from Littler. We also have a tool in the Document Center that helps you create offer letters and NDAs and other kinds of compliant documents. But the star of our show today is Policy Smart. That's most relevant to what we're doing today. And Policy Smart provides handbook templates, checklists, proactive news, and much, much more. Our clients love the Policy News feed, the Policy Smart news feed, because it's a proactive place. We keep you informed on new developments, cases, regulations, much more. We have an entire department, a knowledge management team, whose sole job is to track legal developments and push out that information, including real-time updates to our policy templates and other resources such as Littler Edge. And we tap you on the shoulder twice a month by sending you an email so you don't have to be in our system every day, give you a reminder what's taking place so that you can go in and stay current in the places that you work. If you're interested in learning more about complianceHR, please say yes to the poll in the right-hand corner of your dashboard. One of our members of our team will contact you, we'll discuss your requirements, we'll review the Navigator suite, and provide you with a trial. If you're in the full screen mode, you might have to exit that to see the poll that's coming up right now. I'll let that run for a minute. Today's meeting will be recorded. It will be distributed with our presentation material after the webinar, And as Jill mentioned, any questions, please put them in the Q&A box and we'll try to answer them for you. All right, well, you guys are all in very, very good hands with two Littler experts, Jill and Greg, who lead the Handbook and Policy Practice Group. Their team creates over 600 handbooks annually across all jurisdictions and industries. And on top of that, they work through hundreds of unique client policies like privacy, paid time off, background checks, and much, much more. The key here is if your handbook is done right, it is easy to make updates, and your handbook really should be a living document. Hello, Greg. Where do we begin?
All right. Thank you, Michael, and thank you, Jill, for that great introduction. So without further ado, we're going to begin our countdown of the top 10 handbook drafting and implementation mistakes that we encounter on a day-to-day basis here at Littler and how to avoid those mistakes. Handbook mistake number 1, not using Littler templates. Since the advent of the first website and the first web browser in the early 90s, employee handbook samples have proliferated online. A Google search for employee handbook sample will generate hundreds of off-the-shelf employee handbooks to choose from. Hoping to save a few bucks, some cost-conscious employers will download a sample employee handbook from the internet and will tailor it without ever consulting with an attorney. The advent of powerful large language models like ChatGPT, Claude, Google Gemini, and Copilot has only accelerated the phenomenon of do-it-yourself handbook and policy work. Anyone with a smartphone or an internet connection and an AI companion thinks that they can generate a legally compliant employee handbook or workplace policy. While these AI tools are incredibly impressive and get better every day, they're not going to take my job or Jill's job anytime soon. Using templates that have not been vetted by a human attorney at Littler carry some serious compliance risks. When reviewing employee handbooks that are created by our clients without our involvement, the members of our practice group often find that these handbooks are missing policy language or even entire policies that are required or strongly recommended by federal, state, or local law. Some of these handbooks exclude best practice language that has been vetted by our teams of subject matter experts or SMEs here at the firm. This best practice language, which we incorporate into our templates, reflects the latest statutory, regulatory, and case law developments, as well as the latest agency enforcement guidance. Finally, some of these handbooks that our clients develop on their own include policy language that creates unnecessary compliance obligations. I recently counseled a small nonprofit client about their compliance obligations under the Federal Family and Medical Leave Act, or FMLA. As many of you in the audience know, an employee is eligible for job-protected leave under the FMLA if they work for a covered employer with 50 or more employees, have worked for the employer for at least 12 months as of the date of their FMLA leave, have worked at least 1,250 hours during the 12-month period immediately prior to the start of their FMLA leave, and work at a location where the employer employs at least 50 employees within a 75-mile radius. Notwithstanding the fact that this small nonprofit client had only 15 employees and was not a covered employer under the FMLA, they had included an FMLA policy in their handbook that they had drafted to promote a family-friendly workplace culture. The FMLA policy only included the 12 months of service and 1,250 hours of eligibility requirements. By including this FMLA policy in their handbook when they did not have to, this small nonprofit client had created a reasonable expectation among its employees that they could take FMLA leave for covered reasons under the law. Failure to provide a requested leave with this policy in their handbook would have been risky for them. Now I'm going to turn it over to Michael to tell you a little bit more about what I'm talking about when I refer to the Littler template. So Michael, do you want to talk about what I'm talking about with those templates?
So the Policy Smart is loaded not only with the national template with over 70 traditional policies, everything you expect from harassment to EEO, it's all in there. And then for every state, there's a breakdown of all the details, a template for state by state. And what's really helpful about this, we also provide checklists on what's required in those states. So at a bare minimum, you can go through, you can see what's required in those states, and you can make sure that your handbook is buttoned up with the most current material right from Littler.
Michael.
So taking us to mistake number 2, not updating the handbook regularly. So let's talk about the importance of keeping your handbook current. Even if a company implements a best-in-class handbook, it only holds its value if the company commits to maintaining it. Think of it as a vehicle. You can buy the newest, fanciest model car on the market, but without regular maintenance, such as replacing worn-out brakes, it becomes a huge liability on the road. Handbooks work the same way. A best-in-class handbook becomes a liability if the company isn't committed to routine maintenance. We all know how quickly laws change. Your handbook has to keep pace or it can quickly become a liability. Here at Littler, we use complianceHR's Policy Smart platform, which allows for real-time updates and ensures client policies reflect the latest legal developments on a regular review cadence, including quarterly, semi-annual, and annual updates.
And I mentioned this earlier. I showed you some of the Policy Smart news, which is great. There's a place where you can go in and see that. We're looking at the news right here. And, I joked about making it a living document. There's no excuse not to make the updates when they need it. When you come into our news feed, you can see our different policies with a required policy, and they come in red. I can add those to my calendar so I don't miss the effective date of the first of the year. So there's no excuse for me not to go and do it as they come up. I get a summary about what it's all about. But the best part is Littler has written a new policy by a Littler attorney that I can cut and paste, put it into my living document before the first comes in and meet that deadline. So there's really no excuse on why you wouldn't keep them up to date if the information comes flowing in and you can take them as they come in. I do hear all the time people hate having to once a year update their handbook or twice a year. If you do a little at the time, it doesn't seem to be so painful. Whoops, did I push you too far? Sorry.
No worries, Michael. So I know at the outset of this webinar series that we said that we were going to focus on the top 10 handbook drafting and implementation mistakes. However, the topic that I'm about to discuss on this slide and the next slide was so substantive that Jill and I decided at the last minute to break it down into subparts A and B. So you can think of subpart B as a little bonus. Handbook mistake number 3A is failing to implement policy changes. Unfortunately, it is not uncommon for employers to engage our firm to revise and update their handbook, only to fail to implement legally required policies and policies that reflect best practices once we deliver the final work product to them. Unfortunately, failure to implement these changes can create significant legal exposure for the employer. Just recently, we had a client reach out because they had received a complaint that was filed with an enforcement agency alleging that their paid sick leave policy was not compliant with the applicable paid sick leave law. Unfortunately, although this client had worked with Littler to update their handbook, including the paid sick leave policy at issue, they never actually implemented the updated handbook. Now, as a result of this oversight, the client is facing the potential for substantial penalties for having a non-compliant paid sick leave policy in the handbook that their employees have. Somewhat related to that is handbook mistake number 3B, which is failing to communicate changes. An up-to-date and compliant employee handbook is an effective tool for minimizing legal risk to your organization, but only if the handbook is distributed to employees in a manner that ensures that they receive actual notice of changes to company policies and company practices. There are various ways to ensure an effective rollout of your updated employee handbook, and some of them are listed here on this slide. Unfortunately, some employers we work with think that their employees have psychic abilities and are aware of changes to company policies and practices without ever being told about them. We recently encountered a botched handbook rollout involving an employer in California, which, if you have any employees there, you know is probably the worst state in the country for an employer to play fast and loose with its compliance obligations. For many years, this client had allowed its employees to accrue vacation time monthly with no accrual cap. During the height of the pandemic, the company decided to update the vacation policy in its handbook to impose an accrual cap for the first time. Under well-settled case law precedent in California, an employer can unilaterally change or terminate a workplace policy if the change becomes effective after a reasonable time, after a reasonable advance notice to the affected employees, and without interfering with vested employee rights. The client's unilateral change to the vacation policy in its employee handbook was effective immediately. Affected employees did not receive any advance notice of the change to the vacation accrual cap. To make matters even worse, the client forgot to implement the accrual cap in its payroll system. As a result, many employees had vacation time accruals reflected on their pay stubs that were far in excess of the new accrual cap in the vacation policy that they secretly updated. When the client came to our paid leave group for advice about how to enforce the accrual cap, they discovered that there was significant legal exposure and employee relations issues that they had created by failing to properly communicate the change to their vacation policy. Had they provided reasonable advance notice to them, and had the change to the accrual policy been taking effect after a reasonable period of time, and had it not interfered with vested employee rights, the client would have been just fine.
On to mistake number 4, including vague or ambiguous language in your policies. When drafting your policies, clarity is key. Vague or ambiguous language in your handbook can lead to misinterpretation, inconsistent enforcement, and ultimately legal exposure. Policies should be written in plain language that is easy for employees to understand and for managers to apply. If a policy leaves room for interpretation, it leaves room for risk. When in doubt, ask yourself, would two different managers interpret this policy the same way? If your answer is no, then it's time to revise it. Otherwise, an employee could claim that they were treated differently because of ill or discriminatory intent, when in reality, the policy just wasn't clear. As a practice group, we also encourage employers to try to avoid what we commonly refer to as legalese. For those of you who don't know what legalese means, it refers to the specialized, formal, and often complex language used in documents and other forms of communication. It is often characterized by technical vocabulary such as here and after, or long, intricate sentences, and is criticized for being difficult to understand by non-attorneys. As an example, if an employee files a lawsuit claiming they were wrongfully discharged, as an employer, you want to be able to show the jury that you had adopted a clear, concise, and understandable policy regarding workplace conduct, and that the employee knew their actions could result in disciplinary action up to and including termination.
On to handbook mistake number 5, inadvertently creating contractual obligations. Employee handbooks and workplace policies must be drafted carefully to avoid creating contractual obligations. Words such as will or shall or must should be avoided. If a handbook policy contains language that is sufficiently definite or mandatory in nature, it may lead employees to interpret that language as a binding and enforceable promise. It may also create exposure if plaintiff counsel can point to non-compliance or inconsistent enforcement of policy language as evidence of unlawful discrimination. The most obvious example that the members of our practice group encounter are detailed progressive discipline policies that are applied in a rigid, step-by-step fashion with little to no discretion for the employer to deviate. On multiple occasions, we have seen plaintiff counsel point to an employer's non-compliance with or inconsistent enforcement of its own progressive discipline policy as evidence of unlawful discrimination. On the first page of Littler's National Employee Handbook template, we include the following language. Quote, "This employee handbook is not a contract and does not constitute an express or implied contract guaranteeing continued employment for any employee." In the standards of conduct policy that we include in our National Employee Handbook template, we include a lengthy list of conduct and job performance issues that may result in disciplinary action up to and including termination of employment. At the end of this list, we include the following disclaimer, quote, "Please note this list is not all-inclusive, and the company may take disciplinary action to address other types of conduct or performance issues or rule violations in its sole discretion." The company reserves the right to determine which type of disciplinary action to issue to an employee. The statement of prohibited conduct does not alter or limit the policy of at-will employment. Either the employee or the company may terminate the employment relationship at any time, for any reason, with or without cause, and with or without notice.
Mistake number 6, using the handbook to create contractual obligations. So you just heard Greg talk about inadvertently creating contractual obligations, but sometimes employers intentionally try to use the handbook to create a binding contract. The handbook should never be used in this manner. When reviewing employee handbooks prepared by clients, we frequently encounter contractual agreements masquerading as handbook policies. Some examples include arbitration agreements, confidentiality agreements, invention assignment agreements, non-competition agreements, non-solicit agreements, and non-disparagement agreements. These agreements are in direct conflict with the disclaimer that often accompanies many handbooks, stating that the handbook is not a contract and does not create any contractual rights. For employers seeking to obtain binding and legally enforceable promises from their employees, a standalone agreement supported by legally sufficient consideration is required. We encourage our multi-state employers to work with Littler subject matter experts to ensure that their agreements are compliant with applicable law, including laws regarding enforceability of non-compete agreements. As you know, they vary widely from state to state, and what will work in one location will not be enforceable in another. Additionally, as an emerging trend, some states are imposing civil and criminal penalties for using an illegal non-compete agreement. So this is a great time to think about your current policies and agreements.
Handbook mistake number 7 involves misalignment of handbook policies and employer practices. Your employee handbook is an effective tool for managing employment law risk only if the policies in the handbook are aligned with your actual practices. This means that you should not include any policies in your handbook that you do not intend to enforce. If a policy in your handbook has outlived its usefulness to the organization and has stopped serving a legitimate business purpose, you should remove it. Otherwise, a manager may decide to dust off this dormant policy and enforce it. If handbook policies are not aligned with actual practices and that they are not enforced or are enforced inconsistently, it can create significant legal risks for your organization. For example, inconsistent application of handbook policies can create perceptions of bias, favoritism, and unequal treatment. This is practically an invitation for discrimination claims under federal and state anti-discrimination laws like Title VII and the Americans with Disabilities Act. Courts will often view inconsistent enforcement of handbook policies as evidence of disparate treatment. Similarly, if an employee engages in legally protected activity, such as reporting unlawful harassment or taking a legally protected leave of absence, and is subsequently disciplined for violating a policy that other employees routinely violate without consequence, it can trigger a retaliation claim. Having a compliant policy that is not enforced or that is enforced inconsistently also increases the risk that a court or a federal, state, or local enforcement agency will impose civil fines and penalties against the employer. Depending on the nature of the non-compliance, criminal penalties may also be on the table, as Jill has previously indicated. Oftentimes in employment litigation, employers need to demonstrate that a challenged adverse employment action was taken for a legitimate, non-discriminatory, non-retaliatory business reason, such as consistent application of a company policy. If an employer cannot demonstrate that the handbook policy in question was applied fairly and consistently across the board, it may find itself in a weak position in litigation. An employer hoping to quickly and efficiently dispose of a claim by means of a motion to dismiss or a motion for summary judgment may unfortunately find itself in the case for the long haul. In many states, employers challenging an application for unemployment benefits will bear the burden of proving that the former employee should be disqualified for violating a company policy. To secure a disqualification, employers must prove that the former employee knew about the policy, that the policy is reasonable, and that the employer consistently enforced that policy. Finally, The perception of unfairness that results from non-enforcement or inconsistent enforcement of handbook policies can have a corrosive effect on the workplace. It can erode trust and confidence between managers and their direct reports. It can also harm morale if employees believe that some employees are receiving preferential treatment.
Mistake number 8, failing to account for your workforce. So I just want to take a quick pause here. We've received a lot of questions, and there's some really great ones that touch on this particular slide. I saw questions about what if we have a population that is primarily Spanish speaking? Should we have the handbook account for that, such as translation? We've had a couple of questions about what do we do for union activity, or where you have unions already subject to a collective bargaining agreement. I also saw, I think, a question about an industry and a question about remote work. So all of these are excellent questions. So actually, when we start a handbook project here at Littler, we have a comprehensive intake questionnaire for new handbook projects that we use. And the questionnaire is really designed to allow us to gather the relevant information necessary to properly tailor the handbook for that particular client. We need to account for business operations. We need to account for the industry it's in, because as you know, certain industries have their own legal requirements that don't apply outside of the industry. You want to know whether we want to know whether your employees are remote, if they're hybrid, are they on site? Do you need a remote work policy? Do you need a bring your own device policy? How many employees do you have? Where do they work? What's the industry? Do you have unionized employees covered by a collective bargaining agreement? We also want to know if you're publicly traded. Are you a not-for-profit? And one of the things that we really have to get into is what's your risk tolerance, right? So some multi-state companies may not be able to guarantee 100% compliance with 100% of the laws 100% of the time. So trying to help clients understand where the risk is and what they can do to get their handbooks and policies in place is a really important part of the handbook process. As you know, these factors will influence the substantive content of the handbook and how policies should be written. For example, if you're in the hospitality industry, you may need to account for predictive scheduling laws. But if you are not covered by a predictive scheduling law, you would definitely not want to include that type of policy in your handbook. And this tracks or goes back to what Greg said earlier about his small not-for-profit client that unfortunately had included the FMLA policy in its handbook, even though it wasn't actually covered by the FMLA. I know with all the changing laws, it's hard. It's hard to keep up. It's hard to be compliant, and a one-size-fits-all approach just doesn't work anymore. But tailoring your handbook to your workforce and accounting for all of these unique issues related to your company is really important to ensure relevance, compliance, and clarity.
Handbook mistake number 9, failing to properly train your managers and supervisors. Many employers fail to appreciate the critical role that managers and supervisors play in employment law risk management. Managers and supervisors are on the front lines of enforcing handbook policies. If they do not understand the policies or their role in enforcing them, your up-to-date and compliant policies may not be enforced or may not be enforced as you had intended. Joe and I have trained countless managers and supervisors as part of the handbook rollout process. We know what an effective handbook rollout looks like. Employers that get it right will explain the why. They will explain to their managers and supervisors why they're implementing the handbook and the handbook's role in communicating expectations, roles and responsibilities in meeting the company's compliance obligations. Employers that get it right will highlight key policies that are likely to be the subject of questions from employees or enforcement activity. These policies that our clients that get it right reinforce include the organization's anti-discrimination policy, the policy prohibiting harassment, leave and accommodation policies, and the standards of conduct, and maybe even a whistleblower policy if there's one in the handbook. Additionally, these employers highlight any policies that have changed from the previous version of the handbook to avoid the unfortunate situation that we mentioned earlier of the California client that secretly updated its vacation time accrual and then forgot to tell anyone about it. Employers that get it right provide managers and supervisors with scenarios demonstrating how handbook policies are put into practice. For example, they may share an example of a real-life situation and ask managers and supervisors to weigh in on how they would handle the situation under the company's policy. Employers that get it right will share with managers and supervisors the consequences of non-compliance. For example, managers and supervisors may not fully grasp that their failure to take prompt and appropriate remedial action in response to a sexual harassment complaint may expose the company to significant legal liability. Additionally, it is often helpful to highlight circumstances under which a manager or supervisor may be held individually, personally liable for their actions or their failure to act. I have found that what I'm going to call a scared straight approach will sometimes get the attention of managers and supervisors who do not take a handbook rollout seriously. Finally, employers that get it right let managers and supervisors know where to go when they have questions or need support. Ideally, managers and supervisors should have a dedicated point of contact in human resources who can provide them with accurate, up-to-date information when they are unsure how to handle a particular situation under one of the company's policies.
On to mistake number 10, lack of an employee acknowledgement. The simple step of obtaining an employee acknowledgement can make a big difference in litigation. As attorneys, we rely on any documents really that employees have signed throughout their employment when we're defending against claims that have been brought in court. As Greg noted earlier, there was a botched handbook rollout in California that resulted in significant legal exposure and employee relations issues that the employer had inadvertently created by failing to properly communicate the change to their vacation policy. Had the client had employees sign an acknowledgement of receipt, the exposure there would have been significantly reduced. As another example in litigation, employees sometimes dispute that they received a copy of the employer's handbook or that they claim that they were not familiar with the company's procedures for raising complaints regarding discrimination and harassment. Without a signed acknowledgement, it is difficult to counteract these assertions. In some cases, the company can lose important affirmative defenses in litigation, including, for example, the Farragher-Ellerth defense, if the company cannot establish that the employee was on notice of the company's anti-harassment policy and the mechanisms for reporting that conduct and failed to utilize those, and that the employee failed to utilize those mechanisms. A signed acknowledgement is essential to support this affirmative defense. In Littler's model acknowledgement, we include best practices language reminding employees of the company's non-discrimination and anti-harassment policies, the specific mechanisms to report the prohibited conduct, and other important information that we want to be able to show to a judge or a jury that the employee knew about as part of their employment. With that, I'm going to turn the presentation back over to Mike. And Mike, you may be muted.
Thank you. I was muted. Sorry, everybody. We have another opportunity if you're interested in getting a trial of complianceHR and meeting with my team to discuss your needs and see how these things work. Click yes to the screen for the poll screen up in the top right-hand corner. Again, if you're in full screen mode, you might need to escape from that for a moment while you do that. A lot of great questions were coming in regarding how frequently handbooks need to be signed and a number of other things about the updates, which I think the team can address in just a moment. But the one thing I will tell you, getting the information, getting it right, vetting it configuring it to the way and the culture of your organization is a great thing to do. But once you get it right, it's always a good idea to pass it back to a Littler, have it give them the once over, make sure you've got everything in there. One of the questions I saw come in is, if I change my content more to the tone of my company, could that potentially impact the policy? Maybe, but those are maybe some of the things we could talk about and some of the questions that came up. But once again, if you're interested in meeting with my team to discuss your requirements and review complianceHR and get a trial, please say yes to the screening poll.
All right,
Jill
so I
and
think
Greg,
now
would
would
you
be
like
an
to answer?
opportune. Yeah, I was going to say now
I'll
would
pass
probably be
it
an
back to
opportune
you.
time for us to dive into these questions. We received a lot of interest and a lot of questions during the presentation. So, Jill, the first question we received is, how do you go about creating a handbook for a unionized company?
Yeah, so that's an excellent question. I think it depends in part on the content of your collective bargaining agreement. We've seen a lot of different types of collective bargaining agreements. Sometimes they have very specific policies within the agreement addressing discipline and attendance and point procedures and things of that nature, which could impact ultimately what is in the handbook. Other times we've seen collective bargaining agreements that actually default to certain handbook provisions. So you'd want to definitely look at those two sort of holistically and make sure that they meld together appropriately. But from my perspective, usually you can have an employee handbook covering unionized employees for topics that are not already addressed and not already inconsistent with the collective bargaining agreement.
I just want to add to that point that the Littler template handbook and the state supplements that we utilize and that are available through complianceHR have been vetted by labor law subject matter experts here at the firm for compliance with the National Labor Relations Act and the latest precedents from the National Labor Relations Board. When we receive a handbook that has been drafted by a client, one of the things that we will often do when we're reviewing the handbook is review for those NLRA and NLRB issues to make sure that the client is not including language in the handbook that may get them in trouble or may run afoul of current law at the NLRB. Okay,
And
our
just
next
to jump,
question here.
wait,
Oh, go
can I
ahead.
jump in just really quickly? Because there's another question that I think is somewhat related to the union question. And it's, how does a code of conduct reconcile with the handbook? And I think that's an excellent question, and we get it all the time. So normally when I do a handbook, I also like to review the code of conduct, even if we aren't retained to review it from a legal compliance perspective. I always want to make sure that what we're putting in the handbook works with what is in the code of conduct, right? So for example, you may have a code of conduct. It's usually much shorter than the handbook, and it touches on very high level topics, right? The things that apply everywhere. I won't lie, we don't steal, we don't cheat, we don't engage in unfair competition. And you want to make sure that the language that you're putting in the handbook works with that. So typically, the code of conduct is really more your overarching ethical obligations that the company is striving to achieve, right? And the handbook a lot of times will have a little bit more detail on that and what is actually expected in terms of practical obligations. All right, Greg, you
Jill,
can pick
another
another
question.
question.
Yeah, we got a great question here. Do you have any recommendations for language regarding sick or vacation time to add pay beyond the standard expected 8 hours per day? Vacation policies and sick leave policies, as Jill can attest, are some of the most complex policies that Littler drafts and provides to our clients. We actually at the firm have what we call the paid leave subgroup, and they day and night are reviewing these policies to address both state and local compliance to make sure that whether it's a PTO policy or a flexible vacation policy or an unlimited vacation policy is compliant with the patchwork quilt of federal, state, and local laws, and that they're not running afoul. Again, Sometimes clients try to be generous and put things in their policies, which actually may not be lawful. So, Jill, did you want to add anything further about the SMEs we work with in the paid leave space?
Yeah, so I'm actually part of, it's interesting you picked that question. I'm actually part of the paid sick leave subgroup, and it is exhausting. We've got a lot of new, not to spoil our upcoming webinar, but we do have some new paid sick leave laws coming into effect, either amendments or new laws. And so it's ever evolving, and you really can't, in my opinion, have a one size fits all paid sick leave policy unless you're giving unlimited annual accrual, unlimited carryover, and unlimited use, right? There's even a small fraction of one law that requires payout of paid sick leave in certain circumstances. So it's really complicated. And so we do have in the Littler templates the individual jurisdictional requirements, right? So we have policies that track to, and this is through Policy Smart and complianceHR, that track to the jurisdictional requirements. If you're not doing a jurisdiction by jurisdiction approach, though, you really need to have somebody helping you that knows what they're doing.
All right, Jill, we received a comment early on in the presentation about signing of the handbook. Someone asked, do employees need to re-sign the handbook every time we update it? As you covered the handbook mistake about the acknowledgement, do you want to talk about what best practices are about getting that sign off every time?
Yeah, and I'm going to throw in a couple of other questions that kind of came up along those lines too, because somebody asked about what happens if if an employee refuses to sign them, what happens, or not what happens, can you have somebody sign it electronically? Is that better than having somebody sign it, with a pen, like a wet signature? So in terms of the updates, there are different approaches on it. From my perspective, if you're holding an employee accountable, I would like, as an attorney, to be able to tell a judge or a jury that they knew about the change and that they signed off, right? So we have proof that they knew about that change. If you're updating on an ongoing basis, I think that becomes a lot more cumbersome and a lot more difficult. I'm not sure if that's really a practical approach for a client that is updating on an ongoing basis. If you're updating, though, semi-annually or annually, absolutely, I would have them re-sign an acknowledgement. In terms of, if an employee decides or refuses to sign the employee acknowledgement, one, it's not a binding contract, so you can really make a note and just say they refuse to sign, and advise them somewhere in writing that they're still obligated to comply with it and they're still subject to discipline. From my perspective, though, honestly, if they're not signing the handbook, you have a different issue on your hands, because there's a reason that they're not signing it, or there's some concern that I think is going on that probably needs a little bit more investigation. In terms of the third related question of the electronic signatures are fine for the employee handbook. What I would like to see when you're doing that, though, is that you run it through a useful HRIS software platform, where you have a record of the employee signing, but two, you really want it set up in a way that it's only the employee who can sign it, right? So they have a login credentials, they have their own unique password. The last thing you want is for them to say, well, I never saw that, I never signed it, my manager has access in the system and he must have signed my name for me. So there are best practices too, just so you know, in terms of what types of electronic signatures will hold up in court. So date stamps are really important. I think they're critical. But there are different software features out there for the electronic signatures, and then which one you pick, I think, depends a little bit on your risk tolerance.
All right. There was a question in the chat, which Michael had alluded to, but I think it's worth bringing to the fore again. The question is, if we use Littler policy templates and modify them to capture the tone and culture of our organization, will a Littler representative review them to ensure that we have not included modifications and customizations that may change the policy language or the intent? The answer to that is yes, we will review modifications to our templates to ensure that required language has not been removed. And again, so we work closely with our clients to get to know them, to get to know their business. And we do a fair amount of customization ourselves because, again, we work with these templates daily and we know what language can come out, what wording we can change without changing the meaning of the policy. Jill, do you have any other thoughts about clients that want to
Yeah,
customize the templates?
The only other thing I would add is there are some policies in the Littler template that are driven just by legal compliance. And so the things like your harassment policy, for example, I generally recommend, if you're going to partner with us in the future for legal updates, or you're going to rely on complianceHR to update them internally yourselves, the fewer changes you make to the actual legal substantive language of the handbook, the easier and more cost effective that review is going to be. So you can put in at the beginning the history of your company, your culture, all of that. You can use your own terms. Some have human resources, some have people and culture. All of those types of changes, yes, absolutely. You want the document to feel like your company. But for the ones where we're really trying to meet a legal obligation, I would err on the side of less revision is more, right? Less is more. But if you want to make revisions, that's fine. We're competent attorneys and we can review your changes too and make sure that you have in there what you need to protect the business in the event of a lawsuit.
All right, we got a great question here from a multi-state client. And the question is, do we really have to include all different state policies, or is it enough to have a disclaimer that state required leaves of absence, for example, will be honored? I'm worried that the handbook will become 200 pages long otherwise. That is a concern. Again, you want the handbook to be an accessible resource for your employees, something that is not 800 pages or 1,000 pages long. But at the same time, the answer to this question depends on your risk tolerance. Again, I personally would not advise a client to adopt that type of approach. So at Littler, we maintain a list of what we call required or essential policies. And one of the policies that we consider essential and that we really want to see in a handbook or a state supplement are paid sick and safe leave policies. Some of the other policies that we consider required or essential include any policy that's required by a statute to appear in an employee handbook, a policy that's included in our standard handbook supplement templates for the state and for which there's a requirement that a written notice or policy be provided to employees, paid family and medical leave policies, meal and rest break policies, including for minors if you employ minors, overtime policies, and policies that the employer must provide to employees in order to avail themselves of an affirmative defense. Again, it's a pretty short list of policies which we consider required or essential, but we strongly recommend that you put them in. So having a disclaimer stating we're going to comply with all leave of absence laws, but don't tell employees what those laws are, is, in my opinion, not a great approach.
Yeah, and one other thing to keep in mind, so when we say required policies, there are law, statutes, regulations that say specifically you have to have a policy in writing and you have to distribute it to your employee. Doesn't necessarily mean it has to be in the handbook, but you have to have the written policy and it needs to be distributed. So the handbook would be the logical place. There are other laws that say specifically, if you have a handbook, you must put this information in the handbook, right? So while the state law disclaimer is great in the sense that it flags at least that there are some state law compliance issues and you're following what the law requires, you're still not hitting sometimes your notice obligations or your distribution obligations.
All right. We have a question in the chat. What is the recommended cadence for overall handbook reviews aside from legal updates?
What do you,
Again, I think it really
aside
varies. I
from
think
legal
at a minimum,
updates?
aside from legal updates, yep. How often should you be looking at your handbook?
It's an excellent question. You know, I've never thought about it outside of the context of legal updates. So that's a great question. I think off the top of my head, I would say when if you have a cultural shift, if you have any significant internal changes. I mean, it's just like the law, right? When your handbook isn't reflecting what your business is or what it wants to be, then it's out of date, and you've got to change. You've got to replace those breaks, or you're going to have that liability we talked about earlier. So I do think keeping a pulse on your corporate culture, for example, would be important in terms of when you should be thinking about updating your handbook for non-legal issues.
I think for legal updates, again, we have many clients that come to us for quarterly updates. We have clients that come to us for semi-annual updates. We have clients that come to us for annual updates. I think any update cadence that's less frequent than annual is probably pretty risky because, again, the laws change from year to year. The legislatures, whether it's a full year session, legislative session, or half year session, there's usually laws that are going to take effect the following year or may take effect immediately. So I think at least annually, you want to be taking a look at your handbook and updating it accordingly.
Yeah, and as Mike pointed out, January 1 and July 1 have typically been the most active from a legislative perspective. But I mean, we have laws that become effective. It's like 120 days after the governor signed. So it's some random Thursday in September, right? So I think in terms of the cadence, I have clients that I do their annual update. Well, I do their handbook updates. Some of them are quarterly, some are semi-annual, and some are annual. And I think it depends a little bit on their ability to push out those revisions effectively to their employees to get the signatures that they need, for example. Risk tolerance is another factor that goes into it. And then part of it too is where you're located, right? So if you're in a Colorado or California or New York, for example, they're really, really active. But if you're in Alabama and Georgia, not quite so much. So that might influence what review cadence you set up as well.
We have a question in the chat. When updating a handbook, how should the employer communicate policy changes to its workforce? That's a great question. There's really no right or wrong answer, I think, to this question. I've seen a number of different ways that have proven to be effective. Everything from town hall meetings where the handbook is discussed and rolled out. I have done, and I'm sure Jill and the members of our practice group have done trainings for employees on the handbook when it rolls out, trainings for managers and supervisors when the handbook rolls out. I've seen employers promulgate memos or emails summarizing key policy changes that have changed from the prior version. So there's really not a right or wrong way to do it, but I think it really depends on your company, your communication preferences, your risk tolerance. There's a lot that goes into deciding what's the best way to roll out the handbook.
Yeah, one other thing too, to just to add to that, it depends too on the types of employees you have, right? So if you have employees that are primarily Spanish speaking, obviously that rollout's going to look a little bit different. One, it's going to be translated, right? But two, sometimes we have employers who have really, really sophisticated, technical code writers, and so for them, reading a 2-page memo outlining the changes to the handbook is fine. But for other people who don't read every day for their job, like a dense 2-page memo about the updates to the handbook, probably not necessarily the most effective. For that type of employee perspective, I would say probably a town hall might be better. So I think it really depends on your industry and your employees and what they're used to in terms of that communication.
Right. we have a great question here. What's the best practice for the handbook when the employer operates in multiple states and also has remote workers across a number of states with varying laws? This is sort of our bread and butter. This is something we deal with daily at the firm. And I think you want to have policies in place that are compliant with the laws of where you have your employees. So as part of our intake process at the firm, we want to know, where do you have employees? How many employees do you have in specific jurisdictions? Some of the employment laws that we encounter on a day-to-day basis are triggered if the employer has even one employee in the jurisdiction. So as part of the getting to know you process, we really need to understand where your employees are, down to the city and town, to make sure that there's no local employment laws that are going to be triggered by having a remote employee in that jurisdiction.
Yeah, and then one other thing that kind of layers onto that, so you have your legal requirements, right? That may be driven by where your employee's working, but you may also have unique policies to a particular sector of your business, right? So we, like, one of my clients has a retail sector within their business. They have a manufacturing sector. They have a research and development sector, and some of those a warehouse, and some of those business units have their own unique policies. So overlaying them with the handbook and the state supplement for legal compliance, and just for from a practical perspective, to make sure you have the right policies in place based on your company is important, right? So that again that's the getting to know you type of intake sheet that we do.
All right. Here's a great question. Would you suggest employers not use a specific language from the law for their policies? So recall what Jill said earlier in our webinar about using legalese. So Jill and I are attorneys, and we, on a day-to-day basis, read statutory text or regulatory text. Oftentimes that is very dense, that has multiple subparts. It's complicated. We went to law school, we passed the bar to do just that. But when you're writing a policy for a handbook or a standalone policy, you want that policy to be accessible and readable and understandable to folks that didn't go to law school. So we try at Littler, when we're developing our templates, to incorporate the essence of the law in the policies that we prepare, but not to make them so dense and so legalese that an employee reading our handbook template would not understand what we're trying to do. It's really important to make it a readable document.
Yeah, and in some of our templates, you may see there's some language where you're like, oh, that seems more legalese than what I was expecting based on the presentation. So there are some statutory requirements where you include specific language in the handbook or in the policy, right? So harassment policies oftentimes under state law have very specific language requirements. New York also has an electronic monitoring statute. So if you've ever looked at it, the statute actually quotes what you have to have your policy say. So it's written, I had to look up actually one of the words because it's some sort of recording. I don't even know, like, I don't even remember what it was, but it was the language. Sometimes the language will have to be a little bit legalese because it's required by the statute, unfortunately.
All right, we have a question here, and I think this goes back to one of the first questions we got. Our workforce is represented by multiple collective bargaining agreements. At what point can we update the employee handbook, and do we need to negotiate those changes? We have labor law subject matter experts here at the firm who advise and counsel clients about whether and how to update their handbooks, and what needs to be negotiated with the union. What does the collective bargaining agreement say? So we would recommend that you consult one of our colleagues here at the firm to discuss any changes to your handbook policies or your procedures before you implement them, because again, you may run afoul of your collective bargaining agreement and your bargaining obligations if you're not doing that. Right. We have about 1 more minute left. Okay, let's see what we have here for questions. here's a good one. Do you recommend having a separate handbook for each country in which the company employs workers, or is handling it through jurisdiction-specific appendices more common? Jill, do you want to take that one?
Yeah, I actually do a fair amount of international work. So the short answer is it depends, right? It depends on what international locations you're in. It depends on what's in your handbook. There are a lot of jurisdictions actually where we do not recommend having a handbook internationally. So typically, what I've seen is usually a US based handbook and then an analysis as it relates to each specific international jurisdiction to decide what makes the most sense. But very, very rarely have I seen a handbook with country specific addenda.
All right, Jill, what do you think? You have time for one more question?
I think we are at time. It is 2 o'clock and I actually have another call I need to jump on.
All right. Actually, I do too. So listen, we appreciate your time and your attention today. This is part one in our multi-part series. If you have any thoughts about future webinars in the series, please do not hesitate to reach out. We are happy to take your ideas and your suggestions. So thank you very much.